to this webinar on understanding parental leave as the employer as part of Employers Assistance's pre-recorded webinar series. My name is Kent Duffy, lead solicitor and senior employment lawyer here at Employers Assistance. In terms of an agenda or an overview regarding understanding parental leave as the employer, we'll be looking at key legislation and employer obligations, parental leave payments and parental leave types, notice requirements in and around starting and ending parental leave, returning to work, keeping in touch days, and where things go wrong, legal risks and claims. Key legislation and employer obligations. The Parental Leave and Employment Protection Act 1987 provides employees who meet specific eligibility criteria with a range of parental leave rights and entitlements. Parental leave is a minimum code legal entitlement, and there can be penalties or implications for particular breaches. So ignorance of the law is no excuse, is the signal in terms of that point. In terms of parental leave entitlement, broadly, an employee can take either up to 52 weeks off work or 26 weeks off work, depending on the eligibility criteria and the application of that, which I'll talk to later in the slides. Continuing on an analysis of the Parental Leave and Employment Protection Act, the key or main consideration an employer must have careful regard to is that there is a statutory or legal obligation that the employer must keep the employee's role open for the duration of their parental leave, subject to very limited exceptions, which are if the employee's position is a key position. This is a very high threshold to meet. Basically a business critical role. It would be in most circumstances quite difficult for an employer to get across that threshold, but it is an option that an employer might want to investigate or consider further. Or the other scenario is a genuine redundancy situation. So we have separate ebooks and webinars on change management and navigating restructures and redundancies, which an employer could investigate or have regard to. The employee is entitled to come back to their role as it stood before they commence parental leave. That's the short point in terms of an employee's statutory right to come back to the job that they were originally employed in before they went off on parental leave, and conversely or equally, an employer must hold that role open for the duration of their parental leave. The other statute or key piece of legislation that employers should have a basic understanding of or careful regard to within the context of parental leave entitlements concerns the Human Rights Act 1993. Essentially, there are 13 prohibited grounds of unlawful discrimination under Section 21 of that Act. Two of those grounds concern the subject of sex, which includes pregnancy and childbirth. So these are unlawful or prohibited grounds of discrimination. An employer must not discriminate against an employee because they're pregnant or because of matters relating to childbirth. Also, family status, and that includes having the responsibility for the care of children or dependents. Understanding parental leave payments as the employer. An employer is not required by law to pay anything additional for parental leave, but sometimes they elect to provide additional benefits or enhancements. For example, topping up an employee who takes parental leave's full pay for particular periods of their parental leave. However, that's not a statutory or legal requirement. That is entirely optional if an employer wants to provide those sorts of enhancements. Parental leave payments are paid by the IRD in one continuous period of up to 26 weeks. An employee must meet the eligibility criteria or test for IRD payments or in order to receive IRD payments. And basically that requires that the employee must have worked an average of 10 hours per week during 26 of the 52 weeks before the due date of the child or the assumption of care of the child. Currently, the maximum payment as at March 2025 for IRD parental leave-based payments is up to $754.87 per week gross. Types of parental leave. Primary carers leave is for employees who meet the 6 months test, and that's up to 26 weeks off work is what primary carers leave provides. Then there is the option for extended leave, and this is for employees who meet the 12 months test, and basically that provides employees who are eligible for it with up to 52 weeks off work for parental leave purposes. The qualifying periods must be met, and this basically means that employees must have either been employed by the same employer for an average of 10 hours in either the previous 6 months or 12 months before the due date or delivery of the child. For example, if an employee meets the 12 months test, then they can take up to 52 weeks off work, being primary carers leave plus extended leave. Other types of parental leave. There's also special leave, and this allows pregnant employees to take up to 10 days unpaid special leave for reasons connected to their pregnancy. For example, if they were feeling unwell, or if they needed to go to doctors or midwife appointments, or perhaps natal classes, these sorts of things. Then there is partners leave, and that allows a partner of a pregnant person to take up to 2 weeks unpaid leave on or around the due date of the child or the assumption of care of the child. Then there is negotiated carers leave, and this allows employees to negotiate parental leave if they're not otherwise entitled to it. So that's if they're not otherwise entitled to the primary carers leave or the extended leave that I referred to earlier. Notice requirements in starting parental leave. Employees who want to take parental leave must notify their employer at least 3 months before the expected due date or assumption of care of the child. And the notice must include the type of parental leave sought, start and finish dates of their parental leave, how long the period of leave will be, any sharing arrangements with their spouse that they might want to take or otherwise apply for, verifying documentation, a medical certificate from a doctor, or otherwise appropriate verification from a midwife. In terms of starting or commencing parental leave, primary carers leave can start up to 6 weeks before the expected due date, or earlier if agreed to by the employer and the employee, or if it's directed by a doctor or midwife. In some scenarios, an employer, if they have very good reasons, for example, safety reasons associated with a pregnant employee being unable to safely or adequately perform their work, then there's also the option for the employer to consider directing or requiring a pregnant employee to commence their parental leave earlier. In terms of returning to work and keeping in touch days, employees must notify their employer at least 21 days before the end of their parental leave whether they will be returning to work or not. An employee does not have the right to demand reduced hours or days following their return from parental leave, but an employer may consider a variation, for example, a temporary or permanent variation to hours and days, or reductions to hours and days if they wish to. If an employee decides to resign, then whilst they're off on parental leave, then their termination date is to be treated as the date they started or originally commenced their parental leave. Keeping in touch days, these allow employees to work up to 64 hours of paid work whilst they're on parental leave without counting as a return to work, and still allows them to keep receiving their parental leave payments through the IRD. However, an employee cannot take keeping in touch days or work keeping in touch days until the child is at least 4 weeks old. Where things go wrong. Legal risk and claims at a very high level. The main problem area for employers in terms of parental leave is simply not taking the time to understand parental leave entitlements, which can lead to breaches and/or employment relationship problems and other legal claims. It's important for employers to be cognizant of the fact that legally they cannot unlawfully discriminate against an employee on grounds of pregnancy. That's something to keep front of mind in terms of all decisions that employers make regarding employees who wish to take parental leave, as it can be a slippery slope or an open knife to a costly and protracted legal dispute where employers are not careful. The employer must keep the employee's role open unless specific legal exemptions apply, which again are very limited and a high threshold. So usually if an employee is eligible to take parental leave, as a minimum, the employer will need to keep the position open as it stood before the employee goes off on parental leave for a minimum of 6 or 12 months, depending on what the employee is otherwise entitled to by way of parental leave entitlements. If an employer breaches their obligations under the law, for example, they treat an employee adversely due to them being pregnant or for reasons related to pregnancy, then that may result in legal claims, for example, unjustified dismissal or unlawful discrimination, etc. Thank you for taking the time to listen to this webinar on understanding parental leave entitlements in New Zealand. I hope you've gained some useful insights or information that you can take away and implement. If you require any further information or support, feel free to reach out. Visit our website on www.employers.co.nz or free phone 0800 15 8000. That's 0800 15 8000 if you're an employer looking for some support or assistance.